are working on campus, especially Reba and Brian, with Wildcats for Compassion, the president and vice president. My name is Nelson Pichardo. I'm a professor here in the Department of Sociology, and I will be moderating tonight's discussion. We're going to introduce our panelists. Well, first I would like to say that this is an important issue. And, however you feel about this issue, it's important that we understand exactly what we want to accomplish, or what the advocates want to accomplish, and whether this law does what it's supposed to do. Okay, and that will be the center of the discussion this evening. On my right, we have those who are supporting the 502 initiative. I'll begin by introducing Roger Roffman, Professor Emeritus, has served on the faculty of the University of Washington School of Social Work since 1972. His degrees are from Boston University, University of Michigan, and the University of California at Berkeley. One emphasis of Roffman's research has been the design and evaluation of interventions in the field of substance abuse, with a particular focus on marijuana dependence. Along with Dr. Robert Stevens, Roffman is a co-editor of The Cannabis Dependence, Its Nature, Consequences, and Treatment, published in 2006 by Cambridge University Press. Roffman also maintains a private practice specializing in substance abuse counseling. Roffman supports this initiative as he puts it, "I believe that legalizing marijuana through a tightly regulated, state-controlled system is likely to be more effective than are the current criminal sanctions in protecting vulnerable adults and adolescents from harms caused by marijuana." Next, I'd like to introduce Mark Cooke. Mark is a policy advisor, is a policy advocate with the ACLU of Washington, working on drug policy issues. He graduated from Washington University in St. Louis in 2007 with a law degree and a master's in social work. While in St. Louis, he worked at the Missouri Institute of Mental Health, researching drug policy issues, including methamphetamine laws and needle exchange programs. Prior to joining the ACLU, Mark practiced family law in Seattle. Before going to graduate school, he worked in the foster care system in San Diego and as a court-appointed special advocate in Atlanta. Mark believes Washington marijuana laws should be reformed because the current criminal laws have failed and do more harm than good. Despite arresting thousands of individuals for marijuana crimes each year, the drug is as prevalent as ever, and the usage rate remains relatively constant. It's time to regulate and tax marijuana. Finally, I'd like to introduce Alex Newhouse. Alex is a Yakima Valley native and Gonzaga School of Law graduate. A farmer for most of his life, he returned home to work the land before accepting a position as a public defender in Yakima. In addition to the criminal justice cases, Alex worked with Team Child, a publicly and privately funded child advocacy group, to obtain services for youth and keep them in school. Alex is a supporter of Initiative 502 because he feels a new approach is needed to address public safety concerns and youth prevention because the status quo is not working. On my left, I have those who are con or opposed to Initiative 502. I'll start with Steve Sarich. Steve is a manager and spokesman for the No on I-502 campaign and the executive director of the Cannabis Action Coalition. For the last 10 years, Mr. Sarich has been an outspoken activist supporting the rights of medical cannabis patients in Washington. Next, I'd like to introduce Douglas Hiatt. Douglas is a Seattle-based attorney and has been a staunch defender of medical marijuana patients for 16 plus years. He is the attorney for the Seattle Hempfest and is director of Sensible Washington, a grassroots organization advocating for cannabis law reform. His late mother used pot to deal with pain of cancer and Crohn's disease, so he has a personal angle here as well. And finally, the shortest introduction of all, Arthur West, an open government activist. So what we have tonight planned is for each side to make an opening statement, correct? Is that how we're going to proceed, Ryan? Yes, that is correct. And then we have some set questions to go through. So, who would like to go first? You guys can go first.
So we're just doing one for the whole table?
Yeah, one, yeah.
I'll go first and then...
Okay. You actually use that mic right there. Okay. Oh, each of you? Okay. Okay. That'll be fine. Yeah, that's fine by me. So each will make their own statements. I did switch at least.
Can you hear me? Hello? Talk real close, I guess. Well, first off, I just want to say thank you all very much for organizing this debate. This is a really important topic. And before we get into the meat of this, I also just want to take a moment to reflect on the opposition side to No 502 and just say that I have great respect for everybody that is trying to reform marijuana laws in Washington State. And I understand that there's a lot of different opinions on 502 and on this topic generally, but just before we get into the actual debate, I just want to say I have great respect for everybody that's trying to reform these laws, and I look forward to having an engaging discussion tonight. With that said, I am asking for your support for 502 tonight, and for you to vote yes when you get your ballot in the mail in approximately 3 weeks from now. And there's three main reasons I want to think about why we need to reform our marijuana laws. The first is that prohibition is simply not working. We have spent literally hundreds of millions of dollars in Washington State trying to enforce marijuana prohibition over the last decade or so. There's roughly 10,000 marijuana possession arrests a year in Washington State for simple possession. Since 2000, there's been well over 100,000 arrests. A conservative estimate for what that has cost Washington State taxpayers is well over $200 million to enforce those laws. We actually have some estimates for what it has cost Kittitas County to arrest, file, and convict people for marijuana crimes in Washington State. And a conservative estimate for that is well over $5 million that it's cost the taxpayers of Kittitas County. So just remember that in this time of tough budgets, that we're literally dedicating millions of dollars to enforcing this prohibitionist law. Another important reason is that our racial disparity in how the laws are enforced is horrific. An African American is roughly 3 times as likely to be arrested, charged, and convicted for a marijuana crime in Washington State than a white person. It's not quite that high for Hispanic and Latino populations, but there's also a racial disparity there. And then when you take a step back and look, is this prohibition and enforcement policy working? The answer is clearly no. And the two most important things to remember that are, what about demand? Is the use of marijuana going down? You know, this is why they passed this law in the first place, to prevent people from using it. The answer is an unequivocal no. Demand is relatively constant. People are using marijuana at very equal rates for all population groups. Arresting all these people, it's not doing a thing about demand. And then there's availability. Is anybody having a hard time getting access to marijuana? In the big picture, the short answer is no. There's literally hundreds of thousands of plants that are eradicated by law enforcement in Washington State alone every year. Hundreds of thousands. Many of them are grown in nearby areas in Yakima County, Kittitas County, Chelan County. Tens of thousands of plants every year are uprooted. And yet, marijuana is still readily available. A 12th grader in Washington State is more likely to have used marijuana in the last month than have just smoked a cigarette. Think about that. More students can smoke marijuana and get their hands on this drug than they do that smoke cigarettes at this point. Our prohibitionist policy is not protecting our youth. And kind of more broadly, we're just not doing a good job of working on the social norms of marijuana. We kind of have this jokey, non-serious reaction to it for a lot of people when they see that it's clearly available, it's clearly being used, and that it's not uniformly enforced. And that's just unfair and doesn't work here. So for those reasons, I'm in support of Initiative 502, and I think that you should be too. Initiative 502 would be a sea change in the law in Washington State. Very simply, it would make non-criminal the possession of amounts of raw marijuana product, 16 ounces of edible marijuana product, and 72 ounces of liquid form marijuana. That would no longer be a crime in Washington State for people over the age of 21. That is remarkable. Beyond that, it would set up a robustly regulated state licensing system for producers, processors, and retailers of marijuana. And if you want to get a sense of what this system would kind of look like, it would be very similar to Washington State's old hard alcohol system. Since we changed the law, you can get it in a lot more places, but previously you would go to a standalone store to buy your hard alcohol. This is a very similar system to what would be set up under Initiative 502. So if you hear that marijuana or I-502 is not real legalization, that is just categorically false. It is legalization. It will no longer be criminal for people 21 and over to possess marijuana, and you'll be able to go to a store and purchase it. Just like is the case with hard alcohol. You have to go purchase it. You're not allowed to distill your own hard alcohol in Washington State. And for those reasons, I'm asking for your vote for yes on 502. It's important that we shift our crucial law enforcement resources to important things like violent crime and now on marijuana prohibition. Beyond that, we need to control this marketplace, cut out the profit for drug cartels, and take advantage of the tax revenue that can be produced by this policy. Thank you.
Well, I want to join Mark and thank the organizers for this event. Being informed about a contentious issue like this requires being able to participate in a debate and hear the various perspectives that we're going to be hearing tonight. So my name is Roger Roffman, and I'm a University of Washington professor of social work. I have been doing research on marijuana dependence and counseling for adults and adolescents for several decades. But I've also been a marijuana reform activist since the 1970s. Back in the mid-1970s, we were fighting for decriminalizing marijuana rather than regulating and legalizing it. Back then, we were trying to get passed in the state of Washington a law that would change the penalties for possessing a small amount of marijuana to a small civil crime. And we almost got there. Our legislation passed in the House of Representatives in 1977, and it did well in the Senate until it died in the Rules Committee of the Senate. I've also been an activist on the medical marijuana issue. Back in the late 1970s, I worked with a state senator, Ted Haley, in writing a bill that created the first medical marijuana law in the state of Washington. And that law set up a statewide medical marijuana research program. That research program permitted doctors to become co-investigators and to enroll their patients as subjects. And therefore, through that law, patients around the state were able to get medical marijuana legally. If legalization meant simply throwing out all of the laws against marijuana, I would not be in support of it, because marijuana is not harmless. For a fairly sizable minority of individuals who use marijuana regularly, marijuana dependence is an outcome. And while it's not life-threatening, and while it's not nearly as serious to public health as heroin addiction, addiction of some other substances, neither is it a minor issue. And if any of you ever have known somebody or yourself have been marijuana dependent, you understand what I mean. Marijuana, unfortunately, derails a fairly substantial percentage of teenagers who use it, derails them from healthy psychosocial development, leading to poor school performance and dropping out of school. Marijuana at an early age can lead to increased risk of psychiatric disorders in adulthood. Marijuana is not harmless. But I believe that a public health alternative to criminalizing marijuana will be more successful in preventing harms. And for that reason, I am a sponsor of Initiative 502. It presents a solid public health approach. And here's what I mean when I talk about public health. First of all, it provides funding for accurate and readily accessible educational information about marijuana and its benefits and its risks. Unfortunately, today, our society is badly misinformed about marijuana. Part of that is the legacy of the reefer madness mentality of earlier decades. Nonetheless, our public, you and I, our parents, our children, our brothers, our sisters, deserve accurate information about the benefits as well as the risks. And very little of that is actually being disseminated. Secondly, a public health approach would put in place and fund prevention programs. We know a great deal about how to help young people avoid getting caught up in alcohol, tobacco, and other drug use. But we don't fund what we know works in most of our communities. Initiative 502, when it becomes law, will devote a substantial amount of the revenue stream from taxation to prevention programs. So I've talked about education and prevention as two prongs of a public health approach. The third is treatment. When this becomes law, the revenues from this initiative will fund a statewide marijuana helpline. And in that helpline, people will be offered not only information about where to get help, but the initiative will fund treatment resources for those people who need some help in stopping or cutting back marijuana smoking. A fourth public health approach, or a prong of public health approach, is monitoring the effectiveness of the new law. And this initiative will fund evaluative research to see what's working so that the regulations can be fine-tuned if it's not working as it's intended to. The initiative will protect public safety by specifying that driving under the influence of marijuana is a threat to the driver and to others on the road. And the initiative will tightly limit the advertising of marijuana and the exploitation of the youth market. It will fund research on marijuana. I-502 is going to take the billions of dollars, I'm right now thinking about nationwide, that are going to the illicit market and funnel them instead to a public health alternative to prohibition. In the 1920s in the United States, the great experiment of prohibition prevented legal commerce in alcohol. It turned out that it worked badly, and the underground economy and the violence associated with prohibition of alcohol ultimately led to its undoing. The state of New York in 1923 repealed its prohibition against alcohol, and gradually a number of other states followed suit, repealing their prohibition laws against alcohol. And in 1933, national prohibition ended. I believe the state of Washington in 2012 is going to begin that same process, and it won't be very long before the federal government will follow the lead of the state of Washington, and we'll see prohibition of marijuana again. Thank you.
So I don't want to repeat too many of the things that Roger and Mark said. So I'll give you a brief introduction about myself and let you know how I approach these issues that we'll be talking about today now. I perhaps, more than anyone involved in the I-502 campaign, know how hardworking and dedicated those involved in the No on I-502 campaign in Sensible, Washington are, and I greatly respect that. I also have a tremendous amount of respect for Mr. Hiatt and Mr. Sarich. They work very hard. I know that. They have both been doing this for a very long time. I'm from Sunnyside, Washington, born and raised on the family farm. I started working full-time on the farm outside of school when I was 14 years old. I was raised conservative. I still stand by those principles. And I'm probably the only conservative up here. If I am not, I would hope somebody would speak up. But, so I do have a unique perspective on these issues. I approach them differently. So I worked on the family farm. I then, in 1999, I attended Central Washington University, and I graduated from here in 2003. I am a Wildcat. This is a fantastic school. After Central Washington University, I did attend Gonzaga University School of Law, and it was then that I started to have a different perspective on marijuana. Before then, I was strictly opposed to its legalization. and I spoke out against it. But I saw a different perspective while attending law school. After graduating from law school, I did get into public criminal defense. I did work in the juvenile justice system on the criminal and civil side of things. And then I did work in Yakima County District Court, representing many clients, oftentimes having as many as 200 open cases at one time, about half of which were DUI. So that was what I did mostly, was DUI. And that's what I still do. About around 2010, I got involved in the Sensible Washington campaign for Initiative 1068. And I collected as many signatures as time would allow, traveled to the Georgia concerts, traveled to Seattle to collect signatures, and I did my best. In 2011, under Initiative 1149, I took on the title of Yakima County Volunteer Coordinator, and I even applied myself to do more as much as time would allow. It's also important to note that between 2009 and now, I became a father. I have 2 children of my own, and nothing changes your perspective on these issues more than having your own children. I evolved. When the Initiative 1149 campaign was winding down, the language to Initiative 502 came out, and I read it several times. And Sensible Washington's official position on it was something that I wasn't willing to accept, and I had to walk away. Since then, I have picked up the Initiative 502 flag, and I have been waving it proudly. I now approach these issues by first asking what is the fiscally responsible thing to do. And instead of repeating everything Mark and Roger said, I think we know what the fiscally responsible thing is to do. We just disagree on how to get there and the regulations that need to be in place when we get there. I also ask myself, what is best for our children? Because that's what matters to me most, and that's what matters to the community that surrounds me the most. I-502 addresses these issues in a way that I am personally comfortable with, and I wholeheartedly support it.
And now for something completely different.
Well, I don't think I can be anywhere near as entertaining as the gentleman in Monty Python. I think that would be a very difficult standard to live up to. But I can assure you that this will, in fact, be something completely different. For those of you that don't know who I am, I'm Douglas Hiatt. I've been a practicing criminal defense attorney for over 20 years. I can't believe I'm this old. But I've been practicing criminal defense in Washington and in federal courts for over 20 years. I did hardcore public defense work for a great percentage of my career, and then I started helping people that were trying to use marijuana as medicine before there was an initiative, before there was a law, before there was anything. I did that under medical necessity theories, which are now being re-argued in front of the state Supreme Court in just a few days, trying to get medical necessity back for patients. And I worked representing people that again, were trying to use marijuana as medicine here in Washington State and in other places across the country, because I practice in federal court all over the place. I think that you would be hard-pressed to find somebody who's more in favor of legalizing marijuana and, in fact, legalizing all drugs and ending the drug war than I am. I've worked with November Coalition, November.org, as Alex alluded and Mark alluded. I'm a co-founder, and I work with Sensible Washington, trying to change marijuana policies here and across the country. And I'm very much in support of legalization. I'm very much in support of telling the truth. I'm very much in support of telling our kids what the truth is about marijuana and other drugs and letting them make responsible choices, letting others make responsible choices. I would love to be supporting a legalization initiative. But unfortunately, contrary to what Mr. Cooke says, 502 is not legalization, period. It does not legalize anything. And if you doubt me, please get a copy of this thing and read it. But you can go to page, I don't know, 26, I think it's in their version. You can read their section 20. And the way they do this, it's a very, very narrow thing. They define the possession of marijuana by an adult 21 years or older, and the amounts that do not exceed those set forth in section 15 of this act is not a violation of this section or other laws. That's not legalization. What that is a super narrow exception for 1 ounce for adults over 21, and it's not a violation of the law. Now, there's a significant difference from something being legal and something being not a violation. Why does that matter? It matters because this initiative leaves every single law that makes marijuana illegal currently on the books. It leaves them untouched. It does not change a single law that makes marijuana illegal. Not growing, not possession, not delivery, not transportation, not drug paraphernalia, I mean nothing changes. You can get absurd results. You can go into the store, buy your legal ounce of weed, come out and hand it to somebody else, it's a delivery. You can smoke a joint, you can hand it to somebody else, it's a delivery. Stuff can get wet, it can gain weight. You go over the amounts, it becomes a crime again. It's not going to change probable cause standards, it's not going to change a damn thing in law enforcement's attitude towards marijuana. It will not be legal. There will be probable cause to investigate still. If you've got it, they can still investigate. It's not legal, okay? That's the problem here. That's the biggest problem, is that this entire campaign is based on a very big lie. They are saying this is marijuana legalization, this is marijuana legalization, legalization's on the ballot. I wish to hell it was, but it isn't. And this ain't it. There is a section in this initiative called Driving Under the Influence of Marijuana. And this section profoundly changes the DUI laws in the state. And it creates new penalties for juveniles and marijuana. I have looked over this section. I have had DUI expert lawyers look over it. Nobody is in disagreement. This section creates a zero tolerance standard for people 16 to 21, under which any amount of detectable marijuana in your system is going to get you a DUI. Period. Now that doesn't have a damn thing to do with impairment. Doesn't have a damn thing to do with being a bad driver or a good driver, or being impaired or being unimpaired. That is a new penalty for pot for kids. It's not tied to impairment. It makes any detectable amount for kids a DUI. If you have kids between the ages of 16 and 21, and your kid goes out and by mistake eats a cookie at a party that's active, or tries a little marijuana, just a little youthful experimentation, and then has the bad luck to get pulled over on the way home while he's still smelling of it, he's going for a blood test. Gonna lose his license. Gonna cost you thousands of dollars. Gonna cause your insurance to go way up and have to file and get special insurance, all sorts of stuff. Here's the other thing about that change to the law. It makes it a per se strict liability standard. What that means is I cannot defend you in court. Whether it makes this change adult or kids, but let's just stay with kids for the time being. I can't defend you. I can't say, hey, you're a medical marijuana patient. I know a couple of young ladies, 17, 19 years old, that are fighting very hard to keep their intestines intact. And they are using medical marijuana. and they are going to be in trouble under this because they are over any detectable amount. Plus, because it's per se strict liability, in other words, get the test, if you're over the amount, that's it, you're out. I can't go to court and defend you. I can't say, this is a medical marijuana patient. She takes this every day. She's got a tolerance. She's totally fine. And oh, by the way, here's a doctor to back her up. And here's another one. And here's some studies. And here's my case, ladies and gentlemen of the jury. I don't get to do any of that. You're going down, and you're going down hard if this thing passes. For adults, they set the limit at 5 nanograms in whole blood. Active THC, not carboxy, which can sometimes be useful determining some things, and whole blood can be useful for others, but if you put a gun to my head, I'd rather have a whole blood test. But the problem with whole blood tests is, and the problem with this standard is, they're trying to get you to believe that this standard is somehow scientifically valid. It is not. The Seattle Times would have you believe that this standard only failed by a vote in Colorado. It's not true. What they failed to mention is it failed 3 times in Colorado. They've been trying to stuff this turkey down our throat. And they're going to bring it back again, because this is Office of National Drug Control Policy. This is their new drug driving initiative. This is how they take chunks of money from the drug war, move it over to a new DUID initiative, and save the funding for folks. Keep the drug war going a little bit longer, like we need that. But anyway, that's what you're going to get. And this 5 nanogram standard has been rejected by Colorado legislature 3 times because we have a research ban on marijuana in this country, and we haven't let doctors and other scientists study it and stuff. We don't know a hell of a lot about driving and impairment. They put this in here so they could pander to soccer moms and other people and try to make them feel good about this thing. The polling they did on this was, well, if we made it this, would we do this? Well, if we shot them, would you vote for it now? That's the kind of thing we're dealing with here. This isn't principled reform. This is something that's been put in there to pander to people that are afraid of marijuana. I don't want to pander to people that are afraid of marijuana. I want to tell them the truth. And the truth about this is that we don't know what the standards ought to be yet on driving, therefore you don't enact them. The truth is, our DUI laws are very, very effective. And the most feared DUI, vehicular homicide, vehicular assault prosecutor in the state, Amy Friedheim of the King County Prosecutor's Office, testified against this very provision when it was there at the legislature. She said, I should have to prove impairment. I don't believe in per se laws, and I don't believe in these limits. I don't believe they're scientifically based. That's a prosecutor telling you that. I tend to listen when they say stuff like that, because they're generally telling the truth about something. So what you've got here is an initiative that doesn't legalize anything, creates a narrow exception for production, for possession and production. Changes the heck out of your DUI law so that I can't defend you anymore. Even if you're an adult, you can't defend yourself. You can't say I'm a medical patient. You can't say I have a tolerance. I've been smoking since I was 12. You can't say anything. You're done. There is no defense. That's what per se strict liability is. No defense. You're going to hear about how probable cause protects you and stuff like that. If you believe probable cause is a significant protection for you and your car, then I have this really beautiful bridge in Brooklyn, and I want to sell it to you. If you think probable cause is going to protect kids of color on Friday and Saturday night from being targets, you're out of your mind. If you don't think that these provisions are going to fall harder on people of color, they are. They absolutely are. Kids of color will be the first people affected under this. And I agree, there's a hell of a racial disparity. When my friend Pete Holmes took over the city attorney's office, he found out for real. He said, I should have known. Yeah, you should have, but now you know for real. 7% of the population is 57% of the cases. Oops. So what you got, again, is an initiative that purports to legalize, doesn't, changes your DUI laws in disastrous ways, and I don't want to hear about how we're going to fix them later. You will never see this headline: legislature reduces penalties for stoned driving. Legislature reduces levels for impaired driving. Those levels have been going down. They started at 15, 12, 10, now they're down at 8. But the bad thing about this is you're not going to get the reform that you want because the entire thing is preemptible. I wish the entire thing was preemptible. The majority of it is preemptible by federal law. And you will never see that production thing. You will never see that tax and regulate system. You will never see any of that revenue. It will be struck down because it is absolutely federally preemptible. It is in direct conflict with federal law. It's not the same as medical marijuana. It's not the same exception. You're very likely to wind up with federal court stopping the reform that you wanted, and you're left with 1 ounce decrimmed, nowhere legal to get it, and some really bad changes to your DUI law. And that's what you're liable to wind up with if you vote for this turkey. I urge you to support marijuana reform. I urge you to get involved and to get people to tell the truth about marijuana. And I desperately, desperately want to see marijuana and hemp legal for farmers, which this doesn't do either, and for other people. And we desperately need this change. But we don't need that change this way. Please do not make a mistake and vote for this thing. I guarantee you, you will regret it.
My name is Steve Sarich, and I'm Executive Director of the Cannabis Action Coalition. My job for the last 10 years has been protecting the rights of medical marijuana patients in the state of Washington. I haven't been involved with any other legalization issues because it's pretty much something I leave Doug and other people who specialize in that. And I got involved with this because this is just plain heinous, and they're lying to you. And somebody who knows what they're doing has to get up and tell you the truth. Douglas is right. This is not legalization in any way, shape, or form. In other words, just by definition, if you want to legalize something, you must remove all laws that made it illegal in the first place. This obviously doesn't do that. And could we do this? Yes, we could. But first you would have to eliminate marijuana from the Controlled Substances Act in the state of Washington, remove all the laws that make it illegal, and then we could set up a system for growing distribution. Without removing it from the Controlled Substances Act, it's infinitely preemptible. And they're telling this really bizarre story how, well, you know, if we do this, I think we're going to twist the Fed's arm and they're going to stop busting us for selling marijuana. We're going to sell 187,000 pounds of marijuana, and we're going to make $2 billion in taxes on it. All sounds really wonderful. And then we're going to have all these wonderful taxes that we can spend on Dr. Roffman here so he can do more studies on all of us who are impaired. I have to apologize. I've got a pretty good idea of what my THC blood content is right now, and I'm pretty sure I'm about 4 times the legal limit. So if I sound too impaired tonight, I hope you guys will understand. We're not going to get anything out of this in the way of state licensed grows, retail stores, industrial hemp is at the level for THC and industrial hemp at 0.3%. Except you can't grow industrial hemp at 0.3%. Really creative of them. So let's forget about all these millions of dollars. If you look at what the Office of Financial Management said in their fiscal note, they didn't say that it was going to make $2 billion in tax revenues. It said it could bring in $2 billion, also said it could bring in 0. The second the Feds challenge it, it's not even going to bring in 0 because we're going to be spending a whole lot of money implementing something that's never going to happen. They put their own provision into this bill in Section 10, Paragraph 9. And this lists all the things the Liquor Control Board must take into consideration when establishing the rules and regulations for these growers and processors and retail stores. And it's A, B, C, D, E. A, the first thing they must consider is the conflict between federal law and state law on marijuana in the state of Washington. At that point, they're going to finish their cup of coffee and their Danish, they're going to go home. They're going to say the same thing the governor did. Well, it's federally illegal. We don't want to get in trouble for making up regulations for something that's illegal. I'm going to be much less generous to the other side because they're lying, and their lying is going to get people thrown in jail. And my job has always been protecting patients and cannabis users, and I'm just not going to let them pull this off. This whole per se drug limit, do you know where it comes from? This is directly from the drug czar's office. If you go to the ONDCP website, search for drug driving, they decided to establish this new and really, I mean, it's a brilliantly devious program. You're going to be able to have an ounce, just better not have it in your system. But that's where it comes from. So if you go to the drug czar's website on the drug driving, you'll find the policy. Oddly enough, that policy was released at the same time they were writing I-502. And the drug czar who wrote the policy happened to be friends with Allison Holcomb and with John McCain when he was a federal prosecutor. Maybe that's why we got the per se DUI law right here for the first time in Washington. Look, they're going to talk to you about, they're going to try to talk to you about carboxy-THC. If you hear the word carboxy-THC tonight, I want everybody to stick their fingers in their ears, okay? Go la 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 la, because this is all BS, all right? There's nothing in this law about carboxy-THC, so we can ignore that. They're doing this, it's kind of like a magician who wants you to watch this hand while he's doing something with this hand. So he wants to talk to you about carboxy. Let's only talk about active THC tonight. The latest study on that comes from Dr. Karshner, who was released in April of this year, and she proved that active THC, not carboxy, didn't test it for carboxy, active THC will stay in a chronic user's blood, and that's patients, for up to 30 days from the last time you used it. What does that mean if you're more than three quarters of the college students going to school here? It means that joint you smoked 3 weeks ago at a party, that's still hanging around in your blood. And you get pulled over, and you know what? You get to call mom and dad because you're coming home. Okay? There's a young lady sitting in the back of this room right now who lost her scholarship, lost her funding 24 hours after she was arrested. Okay? And she hasn't even gone to court and had to drop out of school. They demanded all of her college loans that day. Okay? And so she's waiting to get back into school. So she can tell you what's going to start happening to you. Then, by the way, you're going to get a whole different class to go to. And it's all about your, maybe you'll get it from Dr. Roffman here, it's all going to be about your drug abuse problem, okay? Because you've got a terrible drug abuse problem now because you tested 1 nanogram. We're going to talk about probable cause. The Washington State Patrol has asked for $2 million to be added to their budget based on I-502. Why do they need $2 million in additional training? They don't know how to pull over people's cars anymore? Or is it something about the handcuffs they don't understand? No, they're going to train them all to be what's called a DRE. That's a drug recognition expert. So when they pull you over and they go, I smell pot, okay? Or worse yet, you pull out your medical marijuana card, or worse yet, you pull out your ounce of legal pot, and they're going to go, as a drug recognition trained officer, I looked at your eyes, and I believe you're stoned. And if I put that down on a piece of paper under I-502, this is a change to the law, if I put that down in writing, that is prima facie evidence, and there's your probable cause right there, and they're taking you to the hospital, and they're going to take your blood. And if you're under 21 and you have any THC in your blood, your college career is over. Now go home and try to get a job with a DUID on your record. I mean, this is not minor stuff. How about you get in a traffic accident. And that traffic accident isn't even your fault. Well, guess what? If they take your blood and you have any THC in your blood, guess whose fault that accident is now? If you're driving with your 2 kids in the car and they pull you over and they pull this BS, oh, I think I smell pot. And believe me, we hear this every single day. That's the most popular phrase to come out of a cop's mouth. They're not only going to tow your car, they have to do that under state law. They're going to take you to the hospital and get your blood tested, but they're going to have Child Protective Services come pick up your kids. And then you're also going to be charged with reckless endangerment because you're driving around with your kids when you're impaired by drugs, and you're never getting those kids back. You're going to be hiring 2 attorneys. The DUI attorney is going to charge about $15,000. I have no idea what the family law attorney is going to charge you to not get your kid back. But these are not minor things, and they're trying to just shove them off like they're no big deal. Drug driving is not impaired driving. This is also from NIDA. This was released in March of 2011. They describe drugs driving refers to operating a vehicle with a measurable quantity of an illegal drug in the driver's body. That's the new prohibition, ladies and gentlemen. They just want to find it in your body. He also goes on to say that drug driving and impairment have no relationship to each other. He says something that's really, really interesting. He is the first one to say it is impossible to determine impairment by blood concentration, THC in the blood. Impossible. This is a guy who likes pot? No. This is the first drug czar under President Nixon. He was the first head of the National Institute on Drug Abuse. And he just wrote this white paper, and was paid for writing this white paper by the National Institute of Drug Abuse. And so if they start talking to you about carboxys here, remember what you did, right? I'll turn the microphone over to somebody else and fill out some good questions.
Good evening. My name is Arthur West. I have to apologize. Mr. Steinborn couldn't be here today, and I'm filling in for him. I'm sure I can't do as good a job as he can, but I can talk about what I know, and I'll do that. I've been advocate of open public government and for greater access to government records for over 20 years. I fought on at least 3 initiative campaigns, all the way back to 1994 and the I-502 campaign. And every year when the legislature tries to restrict the people's right of initiative, I'm there sitting next to Tim Lyman, arguing against it for the people's right to propose legislation. And I would support that. But this initiative is not the people's right, is not an expression of the people's will. This is the will of 2 large national corporations, the ACLU and NORML, who decided they would get together and propose an initiative. Write, fund, propose it, staff the booths, do everything. If you look at the PDC filings, NORML's paying $10,000 a month for their drug policy director to run the 502 campaign. All 12 chapters of the ACL of NORML in this state are supporting this. This initiative is not a grassroots thing from the people. This is a backhanded creation that was created in a back room by Allison Holcomb working as a drug policy director of the ACLU in combination with NORML. And these 2 large national organizations have an agenda that is not that of the people of the state of Washington. Now, I've been a pot user for at least 30 years. And most of that time, I have been driving pretty constantly with a blood alcohol level of 5 nanograms or higher. I've never been responsible for an accident in all of that time. If the truth about drug driving was that these people are trying to tell you was true, I'd be dead by now, as probably Mr. Sarich would be, and maybe half of the people in this audience today. Alcohol and marijuana are not the same. There is no scientific basis to treat them the same. And this initiative is a scam that was devised by two large national corporations, was funded and supported. And if you look at the PDC reports, they have over $3 million that they're spending to try to jam this down the throats of the citizens of the state of Washington. We've got less than $5,000, but I think with the truth and dedicated staff, we're going to win this one, because I don't think that this initiative is supported by the people. I think it's a hollow initiative that's been put forward by two large national corporations that are supposed to be 501c3 corporations. They're not supposed to even be involved in political activity. So just look where the money is and look at that, and I think that should guide you. As a conclusion, I'd like to say I do respect the people on the other side of this board, especially Mr. Roffman, because I always respect things that I'm afraid of, and I'm scared. I'm terribly scared of Mr. Roffman, because when they bust me and throw me in jail for having 5.1 nanograms in my blood, I think someone like Mr. Roffman is going to be in charge of rehabilitating me and putting me through some form of a treatment program for years and years while I'm walking back and forth for my problem with marijuana. Thank you very much.
Okay, I think your positions were well stated, and there's a clear disagreement on the issue. Now, my task here is I have a list of 6 questions, which we're going to ask of each of the participants. I'm asked to keep you to 3 minutes, so we can proceed. If you have no comment or want to pass, that's okay. All right, so, and I don't care who goes first, really, quite frankly. Under the current law, cannabis is banned from campuses across the state and is so protected via state law. With federal law still prohibiting the use of and possession of cannabis, what risk does this bring to institutions of higher learning regarding the use and possession now that a state law will be lacking? This is poorly written here. Allowing these institutions to enforce state law will be lacking, allowing these institutions to enforce a ban. I should have added these first, Brian. Okay. What effect will it have on campuses? Let's just go with that.
I mean, I think that may be, the intent of the question. Currently in Washington State, marijuana is illegal. Okay, it's illegal for all purposes, all the time, every day, 24 hours a day, 7 days a week. It's illegal, period. If you are a medical marijuana patient, you have a narrow, limited, affirmative defense ability to defend yourself. That's where we're at. Schools and universities typically ban marijuana on campus and stuff like that. That's a result of policy or federal funds or federal grants. That does not affect your ability to raise a defense to a criminal charge of possession or growing marijuana. But the policies that prohibit marijuana on campuses apply, and you cannot fight those effectively without real legalization, and 502 would not be it, in my opinion. It would not be legalization that would allow you to say those federal policies or those state policies controlling those institutions have to change. So I mean, I don't think that 502 would affect the current situation as far as marijuana and schools. I don't think it would have any effect.
Anybody else want to respond to that? Yeah, I mean, truthfully, I agree with mostly what Douglas was saying there. But, in addition to the state criminal laws that might be incorporated in the university's kind of disciplinary policies, the schools have a fair amount of autonomy on how they want to regulate, things on campus. 502 doesn't, for example, go in and change Central Washington University's disciplinary code. That's not what it does. But to the extent that somebody was charged under state law for the crime of possessing marijuana, and that person was age over 21, that would change it. I would disagree with the assertion over there that it's not legalization, that you need to go line by line and take that Uniform Controlled Substances Act. You don't need to do that. 502 makes possession of those amounts for people 21 and over no longer criminal under Washington state law.
I'm going to edit some of these questions because, in my opinion, some of these have already been addressed by the speakers, so give me a moment. Will 502 make marijuana more available to teenagers?
No. No, because I gotta tell you right now, teenagers don't have any problem with getting marijuana. It's easier for them to get marijuana than it is for them to get alcohol. How do I know this? Because when I went to the liquor store a few months ago, and a young man approached me and said, hey, I think because I have a ponytail, hey, would you like some marijuana? I will trade you some marijuana if you will buy me some alcohol. And I was like, do you have any idea who you're talking to, bro? You gotta be kidding me, right? But that's one of the ways I know, and I have two daughters who are now 26 and 28 years old. And I believe that they, and probably every single kid that was at my house the entire time they were all teenagers, had access to marijuana and could get marijuana. And they were experimenting and trying marijuana here and there. That's the whole problem with the whole war on drugs. By the time, you get around to talking to your kids, they've already done it, you lie to them, you lose your credibility, you're toast. So sticking to the truth and telling your kids the truth is the best way to prevent them from getting involved in anything. Having a good relationship and telling them the truth.
Well, I agree with Doug. There's ready availability for young people to access marijuana. As a matter of fact, a study recently was conducted that compared the United States, adolescents in the United States, with adolescents in 36 European countries. And adolescents in the United States were most likely to say that marijuana is readily available. They were also least likely to say that marijuana use could be harmful. So I want to segue from, is the legalization of marijuana under 502 likely to increase availability of marijuana to teenagers? I think it's the wrong question. I think the right question is, will the enactment of I-502 help change the norms about what's healthy, responsible behavior? I think today, in part because of so much misinformation about marijuana, including a lot of drug war rhetoric, young people and not so young people dismiss warnings about marijuana as simply propaganda. We need to start moving away from that to believable, credible information about how marijuana smoking will affect your health. If you're 15 or 50 or 70, if your family has a history of psychotic illness, if you have a history of cardiovascular disease, if you're undergoing cancer chemotherapy and are not benefiting from antiemetic medications, we need to go to more accurate, believable education about the risks and the benefits of marijuana. We need to move away from the hyperbole and the exaggeration and the gross misinformation that exists today. So I don't think it's a question of availability. We've already ceilinged out on that. What I think is I-502 would help us move in the direction of helping young people and older people have healthier norms about what's cool, responsible, and healthy than we have seen, what we're seeing today.
And if I may intercede here, I concur with both the speakers here. Looking at the history of drug prohibition in this country, our government has lied to us constantly about the effects, and it has rebounded to a negative because people disregard the information they are getting. They say, you lied about this, you must be lying about that, and the absolute truth is the only way to go.
Yeah, it's the only way, and I think that's how we've progressed recently. We've progressed in the last 10 years or so because we have a class of people, i.e. doctors, who have been talking to us about marijuana, and they have been telling us the truth about marijuana and some of these health concerns that Dr. Roffman's talking about. And these doctors and guys doing research all over the world. I personally have read or looked at over 400 peer-reviewed medical papers trying to do my job. There are over 4,000 now. We are not the leading country in the publication of research papers anymore, because after 8 years of the Bush administration, nobody even gave a damn about science anymore. Since the Earth was only 5,000 years old, we didn't need to worry about this stuff. But at any rate, that's how we learned about marijuana. That's how we're learning about marijuana going forward. Of course, we need more research. You know, we need more money put towards research, and we need a change in the law so that we can do the research. You know, I mean, it's impossible to get a certificate of confidentiality. There's been one granted on medical marijuana research, and you're looking at the lawyer that got it for Dr. Carter and Dr. Agarwal, and resulted in the publication of a peer-reviewed paper this year. But there's no question that the only way out of this mess is science, and rigorous science, and better and, you know, more information.
Sorry, this question's not on there, but I'm going to ask it anyway. How do you feel about reclassifying marijuana in terms of its Schedule 1?
The doctor that I work with primarily is the doctor that wrote the rescheduling petition for the medical backing for the rescheduling petition for Governor Gregoire. His name is Dr. Greg Carter. And unfortunately, that rescheduling petition, you know, became something political. And they wanted to move it down to a schedule, still be a prescription drug, that kind of thing. That is inconsistent with what both of the authors, Dr. Carter and Dr. Mellamy, you know, were trying to point out. They were trying to point out that this needed to be de-scheduled. It doesn't need to be scheduled at all in their view. It doesn't need to be a prescription drug in their view. It is, it could be and should be available as an over-the-counter supplement, again, in their view. So I think the thing to do with marijuana is to remove it from the schedule of controlled substances, because it is not a lethal substance, it doesn't have great potential for abuse, and it does have therapeutic application. And I think that the science is ultimately going to lead us to that position.
I agree with Douglas. Matter of fact, let me tell you where Governor Gregoire was trying to screw us. She got together with Chris Christie, both governors hate marijuana, and they said, they petitioned the DOJ to move it to Schedule 2. Well, that's a really interesting trick, because Schedule 2 drugs you can only get from a pharmacist, and pharmacists don't sell marijuana. So this was just another very, very tricky way to circumvent what we've got right now. It has to be, I agree with Doug, it has to be unscheduled. It's not legal, but it's unscheduled. Don't think of a pharmaceutical model, think of an herbal medicine kind of model. And that, because that's what it is. It's an herb, and everybody knows it. And I mean, if they want to take and make medicines out of it and sell that in a prescription, that's fine with us. But let us have a plan. I-502 doesn't do that.
How do you feel about this?
I'm going to very strongly disagree that marijuana is not subject to abuse, does not have potential harmful effects to health and behavior. And I want to just offer to anybody in the audience, if you would like, I would be happy to send you a PDF file of a review chapter on the effects of marijuana on health and behavior from the volume that I'm holding in my hands. Now, this was published by international scholars. There are 5 authors of this. International scholars who share 2 positions. First, they are pro-legalization of marijuana, and they are also scientists. And the report that I'm holding, published by Oxford University Press, is titled Cannabis Policy Moving Beyond Stalemate. Should you want to have a copy of a PDF file of the chapter that reviews the effects of marijuana on health and behavior, give me a piece of paper with your email address, and I will send you a PDF copy. To say that this audience or to any other audience that marijuana is not a drug subject to abuse.
I said
is
no.
highly
Let me correct that.
irresponsible.
Hold on. I didn't say it wasn't a drug subject to abuse. Damn it.
Listen to what I said.
Okay.
What I said was, it is not a Schedule I drug because it has therapeutic value and it does not have a high potential for abuse, which is the standard for Schedule I. I don't believe that it has a high standard for abuse, and I believe it's been established it's non-lethal. So in that sense, I don't believe it qualifies for Schedule I. I never said, nor will you ever hear me say, that marijuana is not capable of abuse. You can abuse anything. You can abuse peanut butter. I don't care to debate that. Your point made there is accepted, Roger. I've never said otherwise.
Okay, just from a policy perspective, just on the scheduling issue. So 502 changes Washington state law, and the drug schedules for Washington state's policy on whether to treat marijuana for adults, in a recreational manner, legalizing marijuana, is really kind of irrelevant. Scheduling is very important more on the federal level because the federal government, DEA, is what determines a healthcare provider's prescriptive authority. So in that sense, rescheduling is exceptionally important. But many states don't even have marijuana on their own federal controlled substances, or not federal, but Controlled Substances Act is Schedule I. There are many states that have it as Schedule III or a separate schedule. It's really kind of a red herring, irrelevant to this policy discussion, very relevant to the federal policy discussion. But for Washington state, you don't need to change Washington state's Controlled Substances Act and strike out marijuana on that schedule to have the effect that 502 would have, which would create a legalized, regulated, and taxed marketplace for adults.
I agree with that to the extent that you can make changes to the criminal law here without changing the schedule. But if you go to sensiblewashington.org and you look at that initiative and you look at what it does, it changes the law and it removes it from the schedule so that you don't have any doubt and so that you can do other affirmative things like hemp and other things. You create a positive, a different form of conflict that allows you to sue to get the rights to do things, which is why I'm hung up on real reform and removing the criminal law aspect of this. There's an argument to be made, for instance, right now, under our current law, that hemp is legal because of the way we've defined marijuana. But of course, you don't see hemp fields, redding fields growing out here or on the Palouse, which I would love to see. And we need more fundamental reform before we can get there, because that's what true legalization means.
I think this underscores the main sticking point of this entire debate. Everyone wants legalization. It's a matter of how do you define legalization? The people off to that side of the podium define legalization as a very tiny exemption whereby you can buy an ounce of weed from a state-sponsored store after it's been taxed over 100%. You won't be able to grow it. You won't be able to possess anything other than sold at the state stores, and there'll still be penalties for having over an ounce. And many of us who've been pursuing legalization, pursuing decriminalization, pursuing marijuana reform for decades, don't think this is enough. When we have legalization, we want it to be real legalization. We want there not to be a criminal penalty for having marijuana. We want people to be able to grow marijuana in small-scale grows in their own houses, because to get rid of the black market, to make the prices fall, the one thing that's going to do that is to make it so commonplace that people won't rob for it, people won't steal for it, and there won't be a black market. To a certain extent, that's what's happening now because of medical marijuana in the state of Washington. There is not the market that existed 10 years ago with people smuggling marijuana into the state. It's a fraction of the size that it was. And there's some thought that part of the impetus behind 502 is to create a state-regulated monopoly so that big, large-scale producers can again dominate the market. And that is exactly the wrong way for marijuana legalization. Legalization means there's no criminal penalty for having marijuana, whether you've got 40 grams or 41 grams, whether you buy it from a state-sponsored store, or whether you buy it from your neighbor or grow it in your backyard. And that's the sticking point. Those of us purists in the movement, those of us who have been fighting this for 30 years or more, have been looking behind our backs for the cops to bust us because we smell like weed, don't think that a limited, tiny exemption like that is enough. And also, we're very concerned about adding these new criminal penalties in something that's called legalization. Because now, instead of being secure to drive down the street and not be busted, I'm going to be more scared than ever that I'm going to be taken out of my car's going to be towed away, my blood's going to be taken. That doesn't happen very, very commonly now. It will be commonplace if I-502 passes. And so the problem with many of us is that we don't view this as legalization. We view this as an escalation on the war on drugs, and it's going to make the status quo worse than it is now. And so that's what they term legalization. That's what we term an escalation of the war on drugs. Thank you.
Okay. I think that's a good summary statement for that side. Would somebody on this side like to make a concluding statement? And after this, we'll open up the floor to questions.
Okay. Well, thank you for listening. It's a fun debate. A couple things I'd just like to address that we heard from the other side. One is this notion that the federal government will never allow this to happen, that the entire law is preempted. And in my opinion, I think that is just wrong. I think that 502 was absolutely drafted in a way to survive the preemption challenge from the federal government. So to say that, simply a court will come in and strike it down, I think is just false. It's not true. If you read the case law, it is very analogous to the medical marijuana cases that have been litigated in places like Michigan and Arizona and California. Don't forget, the federal government doesn't differentiate between medical marijuana and recreational marijuana. Therefore, the legal arguments are exactly the same when states are trying to regulate and take control of this marketplace. Look at a state like New Mexico that has robustly regulated medical marijuana. Highly licensed system. The federal government hasn't cracked down there, and it's the exact same legal arguments that would be presented under 502. So that federalism argument is just incorrect. The DUI argument, I really, I just have to disagree with how they're representing the science. Please read the science for yourself. I'm not saying we're going to settle it up here today because they will cite their own studies. Take the time to read the peer-reviewed materials that examine at what point a person's active THC level in their blood is more likely to lead to a car accident.
What's that mean?
You're on the New Approach Washington website. Please read them.
By the way, you failed to mention Colorado, where they closed down 57 state licensed, highly regulated, and highly taxed state licensed dispensaries. 57 of them closed down by the feds, and you just bring up New Mexico where they haven't done it yet.
And yet, Mr. Sarich, there's still many dispensaries still operating under Colorado's licensing system. So I don't think you can dismiss it completely. And I'll wrap up quickly. In our summary statement, please just read the initiative for yourself. This is real legalization. It will free up law enforcement resources to focus on more important matters. It will produce new tax revenue for our state, and it will finally set up a marketplace that we can all accept. Thank you.
Folks, I want to extend thank yous to all our panelists today. I think they deserve a real big round of applause. The worst kind of citizen is a citizen who is a low information citizen. What he said goes. What they said goes. Read it for yourselves. Okay? Make up your own minds. That's what we're here for, to present information, both sides. And you should not just listen to these folks, you should read it for yourselves. All right? Are there any questions from the audience? Yes?
Yes. First off, let me say, I appreciate y'all coming, but I have a serious question for you three. As a seriously ill woman, terminally ill, as it is now, I can have a friend grow it and give it to me. How the hell do you think I'm going to be able to get this medication that makes it so I can eat, so I can sleep, so that I can sit up if I have to pay taxes and I have to pay some corporation to grow it? That's ridiculous to ask of an ordinary, everyday citizen.
Well,
Who do you think's going to be able to afford it? Ain't going to be people like me.
the short answer is, if you were lawfully utilizing Washington State's medical marijuana law, 502 doesn't change that one bit.
If I heard what they said, and I'm just going to repeat, if she gets high because of her pain, doesn't get high for a week, gets in a car, then she can get busted, yes?
That wasn't her question, that's pretty unfair.
No, if I have to pay the taxes, it does.
You don't have to.
It does.
The medical marijuana law doesn't change.
No, but what he says is it doesn't affect any medical marijuana uses.
No, I said it doesn't change
Hold
the
on.
law.
The law. But it does it not, is not the argument that they present? And I'm just listening, okay? I don't have a position on this, I actually don't, all right? Does it, what they say regarding DUID apply to
Her question was,
Would she get an exemption from the law if she said, I got a medical marijuana?
her question was, would she have to pay the taxes? My question, my statement to that is that if you are lawfully getting your marijuana under Washington Medical Use of Marijuana Act, Medical Use of Cannabis Act now that's been amended, 502 doesn't change our CWU 6951A, which is our Medical Use of Cannabis Act. So you can keep accessing medicine the way you already are. In terms of your question for the DUI, I would say that, it's misrepresented that she's going to be above 5 nanometers per milliliter after a week. The research shows that it goes down fairly quickly.
And you're.
Hold on a second, hold on a second. Mark, I think, is making the point that technically 502 does not affect the state's medical marijuana law. Technically, it does not affect. I know that people have concerns about that. They have concerns about what will happen to the market, what will happen to licensing, all that kind of stuff. And I do think that the initiative itself, because it delegates so much rulemaking authority, it does not spell out the production chain and what it's going to do and stuff. I think there are some dangers there, and you could have 502 affecting, quote unquote markets, but it doesn't take away your ability to defend yourself. It doesn't take away your ability to grow for yourself. The problem with the DUI stuff, or Mark is saying if you use and then you don't use, for a week and then it goes down, I mean, the way in which people, and unfortunately, I've been dealing with drug tests and drug testing for my entire 20-year career, and I've become something of an expert on testing for marijuana and how long it will be in your body and all that other kind of crap. And the issue here is, whether or not you're going to have enough in your body to test as impaired if you're an adult, 5 nanograms or more. Of course, as we know, with kids, it's zero tolerance. So, the problem with patients is that patients use staggering amounts of marijuana as opposed to normal, quote-unquote, recreational users. When I represent recreational users that go out, they smoke once a week or they smoke on a Friday night, their concern about impairment is going to be a lot less than a patient's concern about impairment. We've had patients tested. They are very, very clearly way the heck over the 5 nanogram limit. They are also very clearly sober drivers. We've had DREs and doctors examine them, and it's clear that by traditional impairment measurement standards, they would not be impaired, but they will be under this initiative.
Okay, next question, please.
Me being Native American, it's hard for my body itself to digest pharmaceutical drugs, i.e. pain pills, antibiotics, and whatnot. For me to relax and feel comfortable sometimes, I have to, what they say, 1 pill every 4 to 6 hours. I take 6 or 7 just to get anything out of it. If I smoke marijuana, get in the car driving down the road because my pain tolerance is different from yours. But it's going to save me being an American for having a high whatever, because even though I'm a marijuana patient.
What saves you is an impairment standard, okay? What saves you is an impairment standard. What everybody is worried about is people that are driving that are screwed up. It doesn't matter what you're screwed up on. If you took drugs that your doctor prescribed to you, if you drank alcohol, if you smoked marijuana, the drugs cause impairment at some level. People are either good or not good at gauging their impairment levels. But you cause impairment with all these drugs. The problem is, alcohol is a very unique drug. It is different from every other drug in the pharmacopoeia. It is the only drug that we all pretty much process and metabolize the same way, with a few variances. Every other drug out there is highly individualized as to how you will metabolize it, whether you will metabolize it fast or slow, what type of metabolizer you are. They have tests for this. Doctors, that's the whole art of dosing that you're talking about. Some people, you give them 2 milligrams of morphine, they go to sleep. Some people, you give them 200 milligrams of morphine, they're fine, they're running around, they're totally normal. It just depends on each person's, the way they break down chemicals and how you metabolize things. We don't have the ability to develop standardized tests for drugs like we do for alcohol. The whole fallacy of trying to make other drugs like alcohol, marijuana like alcohol, methamphetamine like that, you can't do it because those other drugs don't operate pharmacologically like alcohol. So what we need to focus on is your driving screwed up? Forget about the drugs in your system. I've got all sorts of blood pressure drugs in my system, maybe some painkillers too. But am I impaired? Is my driving screwed up as a result of that? Impairment-based science, that's what we're looking for. Not per se standards, not no defense, not just set levels, but impairment. When you set a zero tolerance standard, you're not talking about that kid being impaired, you're just talking about penalizing that kid for using an illegal substance. It's about impairment. They need to be able to prove that whatever the hell you took has impaired your driving. Doesn't matter how much of it you took, it just matters that it impaired your driving. Okay. And that's where we need to be, impairment-based driving laws, not these ridiculous per se
Okay.
laws.
This DUI issue comes up a lot. And I'm going to be honest with all of you. I'm very blunt, and I don't make any apologies for it. I state it as I see it. I have worked in Yakima County. It is on the eastern side of the mountains. And what you've got to understand is how the DUI process works on this side of the mountain. Okay, I don't have any experience on the other side of the mountains, but I do have substantial experience over here. Okay? Basically what the officers are looking for is erratic driving or equipment malfunction. They're going to pull you over and they're going to be smelling for things, either burnt marijuana, green marijuana, visual observations of you being high. And yes, what the officer says is pretty hard to overcome in court. I agree with that. But anyway, if they see erratic driving, they smell marijuana, it gives them grounds to further investigate the DUI. If there's no alcohol on your breath, or the PBT shows up as 0, or the BAC shows up as 0, the data master machine that you blow into at the station shows up as 0, they have grounds to investigate this further, either get a warrant for a blood draw, get a DRE exam. At some point they are going to inform you about your rights for returning. There are strict rules in place. For example, right now your blood has to be drawn from an expert, or not an expert, I'm sorry, somebody like a phlebotomist, somebody who is trained to do it. Right now in Yakima County, if you have active THC in your system, it doesn't matter if it's 1, 2, 3, 4, they are going to charge you with DUI. They are going to charge you with DUI. I have represented many of them. I've actually represented somebody that didn't have any active THC in their system, just carboxy. They're going to charge you with a DUI. And if you've had it prior, it's going to be very difficult to negotiate that sucker down. Okay? And a lot of people do not have the resources to do it.
But you have
Of the several hundred clients that I have represented over the past few years, I will admit to you, I am honest, I have only had about 30 clients charged with drug DUIs, and there's probably maybe, I want to say maybe 10 of those were other types of drugs, like prescription drugs and stuff like that. But out of all of them that I represented with the green DUIs, there was only one person who had 5 nanograms in their system. She was not a patient. Okay, the 2 legitimate patients that I represented were charged with DUI because of prescription medications in their system. I am not seeing this, at least in my county. This is what's happening. Under 502, at least in my county, it is not going to hurt us. It's going to help us. Because there are currently more people, I have represented more people who are being charged with possession than green DUI. At least in my county, that's what I'm seeing. We're hearing this talk about it's a narrow exception, and it's pandering. Well, you know what? I am willing to accept the narrow exception. They call it pandering, but I'm calling it working with reality. You cannot ignore the people on this side of the mountain. You've got to be in these places where I speak. What they call me. You got to appeal to a greater audience. King County cannot pass an initiative legalizing marijuana on its own. It can't. There's no way. And I have read the literature out there. I can't quote it off the top of my head. Several people have posted it online. I've done the research. I've read everything Anthony Martinelli has posted. There is a handful of literature out there on driving while impaired on marijuana. There's a handful. There's not very much. This is a relatively new area, and we're talking about legalizing a recreational drug. Legalizing a recreational drug that can impair relatively easily. People on my side of the mountains, especially in my community, are very wary of this. Okay?
I understand that, Alex.
Do this on its own.
I understand that. I understand people are worried about it. But here's the problem. You're talking about it's going to help you here because it's going to set standards and that stuff, and you're not seeing it here. Look at the jump. They had a 250% increase in Nevada when they passed these laws. The other problem is, and the biggest problem we've got here in Washington State is, and I'll tell you what it is, those 10,000 possession arrests that they're talking about, those 10,000 arrests, over 90%, probably over 95% of those 10,000 arrests occur as a result of a traffic stop. It is not going to be that difficult, and you may not have very many of them in Yakima County, but I'm telling you that those 10,000 possession arrests, a lot of those occur in the city, a lot of those occurs where people are getting stopped, and there are people of color getting stopped, and police officers are going to be able to turn a possession case into a DUI, especially if you're under 21, and especially if you've got marijuana smelling in the car, especially if you're a patient, something like that. They can take 10,000 DUIs and they can turn them into 10,000, they can take 10,000 possessions and turn them into 10,000 DUIs. And with the new law that changed August 1st, where they can draw your blood now, okay, and they are training state patrol guys like crazy, and they're coming up with these oral tests, and they got a whole bunch of stuff on the way. Don't tell me they don't have oral tests, because look at the copy of the debate from Whidbey Island. I'm waving one around in my hand. Okay, I've seen them. That's the strategy, okay, that's going to get us in trouble, is because those possession arrests can turn into, there it is. Yeah, see, this is what they look like. They're already out there. I got this from a doctor who goes to the federal drug testing seminars and stuff, because he does drug testing for pilots and people, merchant marine and all this stuff. This is what they're starting to go into, so they can find out all the drugs you're on the side of the road. Now they can pull your blood on the side of the road, because they're going to have state patrol officers ready to take your blood. They're going to be trained phlebotomists.
The other thing...
That's the potential for abuse here that scares the heck out of me. And I think should scare the heck out of all y'all. It's the possession arrests come from traffic stops. Officers aren't busting into homes to bust people smoking a joint. They're after two things: people on the roads because they know they can get you there, or they're after plans.
The other thing that I think is important to highlight is that a per se standard doesn't make the DUI laws better. It makes them worse, and it leads to more convictions. Right now, they have to prove impairment. Yes, they can charge you for driving with THC in your blood, but when you go to court, the state has to show you're impaired. What the per se limit does is it removes the impairment defense. And it doesn't make anything better, because even with a per se law, they can still charge you for being under it. You can get a DUI conviction for having less than 0.08 in your blood if you're driving impaired. And that is the real standard. That's what we ought to concentrate on if we're really dealing with unsafe driving. So a per se standard doesn't make it harder for them to bust you for DUI. It makes it easier, and that's one of the big lies that they're telling in this campaign.
Okay. I'm going to give you guys one last chance to respond, if you wish to.
Gentleman has a question there. He's standing right there.
I've worked 40 years in the transportation industry, and all of us know a man named Ricky Gates. And Ricky Gates ran a signal with 4 light engines in Maryland, crippled crack coming down the 2 and pulled out in front of the Amtrak. And his excuse for the reason that he missed the signal, had he said he just ran a red light or anything else, was of course that he and Braitman was smoking marijuana. And of course this saved his job, because saying he was impaired on marijuana, he took the 3-month drug treatment and was back to work in 3 months as soon as he could test. And so we were randomly tested for 35 or 40 years as a result of Ricky Gates. But there were 29 people dead in that Amtrak passenger train when they ran into him. And so the real question comes down to the question of was him and Braitman smoking marijuana on those engines? Were they impaired or were they not? And I don't know that they can even answer that today. But they said they were, because that was the only answer that they could give and get their job back.
That's not unusual. I wish that was a cautionary tale that only occurred once, but it's occurred more times than just Ricky Gates, and yeah, I'm familiar with it.
As reliable scientific evidence of impairment due to THC, I think it falls a little bit short of the standard of repeatable scientific testing, though.
I have a quick question. For Mr. Hiatt, if I could. Where are you getting zero tolerance per se for kids 16 to 21? Under what section of I-502? Per se DUI.
It's in the section
Is it 34?
that is called,
And perhaps I might clarify this decision, because I believe that the law doesn't actually say DUI. They have another name for it, but it's DUI under another name. And it's a technical word.
And then
It's a technical. What's a misdemeanor now?
Hold on. I have the initiative right here. I carry it around with me for this very purpose. And if people want to come up and look at it afterwards, or if you want to go online and look it up, it's Part 5. It's driving under the influence of marijuana. And if you read this entire section, you will find that they set a zero tolerance standard for kids 16 to 21, and they set a 5 nanogram standard for adults, and those standards are per se. I don't know anyone that has come to a different conclusion legally that has read this. Myself, I've read this, all the lawyers I know have read this, and as far as I know, their campaign's own literature basically says this is what we did. Ms. Holcomb defended it and said she did it in order to gain votes, and she had a poll that proved she gained votes doing it that way. I don't really think it's up for debate, Alex.
There's a zero tolerance provision. What he's talking about is there's a technical nomenclature difficulty in this, wherein if they're between 5 and 0, they call it by a different name.
Well,
the
here's what
penalty
it
is
says.
slightly
I'll just
lesser,
read
but
it.
there is zero tolerance, and you do.
The driver is
get
age 21 or over, and the test indicates the alcohol concentration of the driver's breath or blood is 8 or more, or that the THC concentration of the driver's blood is 5 or more. Drivers under the age of 21, the test indicates either that the alcohol concentration is 0.2 or more, or that the THC concentration of the driver's blood is above 0.00. And that's a zero tolerance standard to me. There are other there are other sections, and in section 6 it restates it. And again, it restates it. If the person is age over 21, the alcohol concentration is blah blah 0.2 or more. If the person or the THC concentration of the person's blood is above 0.00. That is page 47, 45, 46, 47. I believe, as does every single criminal defense attorney that I know, and I wish Jeff was here tonight, that creates a zero tolerance standard. It says it does, I believe him, and that's how it's going to be construed. It's zero tolerance standard 16 to 21, it's 5 nanograms over that, and they are strict liability per se laws with no defense possible, period.
Any response?
What we currently have in Washington State is a 0.02% tolerance for alcohol. It's under section 4661.503 of the criminal code. And that 0.02 is due to the amount of products we have on the market that are available to minors that have alcohol in them. Essentially what 502 does is it amends RCW 4661.503 to include a zero tolerance THC limit. If you are charged under that, it is not charged as a DUI. It is a minor operating a vehicle after having consumed cannabis.
Unfortunately, Alex, I know your argument there, Alex, but I've got a copy of 46. I've got a copy of 4620-308 right here, Alex.
Please allow me.
It is a misdemeanor. Okay, it does not involve impairment, and I think it is an effective way to deter minors, people under 21, from using marijuana, hanging around people that can use marijuana, and driving after using marijuana. People are charged under 503 all the time right now, and oftentimes those convictions or those charges are resolved in ways that do not involve conviction.
Okay, and the problem with that is, and I agree, I'm holding RCW 4620 in my hand. That's what he's alluding to. And I know that lots of people wish that 502 actually amended 46, or that there's anything in 46 that's going to alter 502. It doesn't. The reason it doesn't is because they failed when they drafted 502 to look at this issue, and they didn't amend 46, they didn't amend 66, and they didn't amend 1346, which is the juvenile code. So I understand there are other ways that some people in some counties have been charging things, but there's only one way you're going to get charged under 502, and it's under their driving under the influence of marijuana section, and it's real clear what's going to happen to you.
Okay, I'm going to sum this up if I may. I came here, my student, Ryan, who organized this, and as we've had discussions on this initiative, I've been asking him lots of questions, trying to get information. I hope this helped you somewhat. I have to say for myself, I have no idea what to believe. I really don't. It all seems a matter of interpretation, a lot of legalistic interpretation involved. That's where I'm always just a little skeptical, because I'm worried about those legal kinds of things. And so I shun away from those kinds of things as a natural order. But however, what we all have agreement on here is the need to reform our marijuana laws. And that is something we should all push for. We can disagree on specific policy. There are certain goals here that I think are worthy goals, and we should work towards, and not allow this to be too divisive among us. Those of us who want marijuana reform here in the state of Washington should not lose sight of that. Thank you all for coming.
Thank you.